Number 255094. The record should reflect Mr. Ross is present here in the courtroom. Executive counsel put your appearances on.
Ryan Ziegler on behalf of people.
Thomas Seeger appearing with and on behalf of Mr. Ross.
This is the date for a final status conference in this case, and a plea cutoff. We currently have trial set to begin on February 18th. Mr. Seeger has been able to talk to Mr. Ross about how he wants to proceed.
I have, Your Honor. Your Honor, it's my understanding that Mr. Ross wishes to proceed to trial and is demanding a trial. I did speak with the prosecuting attorney. He probably has a request that he would like to make, which I would oppose, but I'll put those reasons on the record following his request if he makes it.
Okay, Mr. Ziegler.
Your Honor, we would be requesting an adjournment of trial. The reason for the adjournment is the court sent out the notice for trial back in November. I reviewed the file in December. I sent subpoenas to the witnesses, and I noticed that we just had a true narc in the file. We did not have the full laboratory report. So my staff sent an email to the officer asking him to get this to the lab as soon as possible. We followed up with him in January, again, asking where we were at on the labs, if they'd be available. We got no response. We called the post yesterday and spoke to a sergeant over there. They informed us that the suspected drugs or paraphernalia were never sent to the lab for testing. So it's unlikely that we are going to have the lab report in the next 2 weeks. Therefore, I'd be asking for an adjournment of trial.
Mr. Seeger.
Your Honor, I guess my response is, I do understand that things happen, and I'm not saying that Mr. Ziegler's office didn't make a good faith effort. But what I am saying is that the matter's been pending for an extensive period of time, which like prior to November, because the matter was bound over well in advance of that. So they've had all this time to get their ducks in a row. They've had all their opportunity to get whatever evidence in advance. It's their burden of proof at all times. He has the right to a speedy trial. He has the right to due process. If it's through their own error or malfeasance, and not Mr. Ziegler's malfeasance, but if it's by virtue of negligence of the charge officer, that's on them. I can't think that, at least in terms of case law, I can't think of that being good cause because the officer was lazy and didn't secure evidence that was requested by the prosecuting attorney's office. That's not good cause. Good cause might be something like if there was a witness who was unavailable for some reasonable reason. This is a situation wherein law enforcement has failed to provide certain evidence that is necessary for the promotion of their case. So if they're able to provide it by February 18th, then I'll examine it. I still think that that's probably not a sufficient period of time because that document should have been provided to me a long period of time ago. And that was part and parcel of my defense that there was a missing lab. But again, I'm not here to curate proofs for the prosecuting attorney either. The only thing I can say is he's demanding the trial. It's set for February 18th. As far as I can tell, there's no good cause to adjourn. If the court finds otherwise, I would just ask the court to create a record as to why that is good cause. But again, Mr. Ross wishes to execute the speedy trial rights. And it's not as if this is a situation wherein, the notice hadn't gone out for a long period of time. This has been set for, I think, around November. So they've had plenty of time to get whatever evidence it is that they need to proceed with their case, which for whatever reason they failed to do. And that's on them. If they proceed to trial without it, then they proceed to trial without it. It may also be the case if the prosecuting attorney does something else. But either which way, Your Honor, it's my understanding that Mr. Ross wishes to have his trial on the 18th and scheduled that way. So unless there's good cause to adjourn it, which I don't see any good cause, I would just ask the court to deny.
All right, thank you. In order to grant an adjournment, the court does have to find good cause. There's a couple factors I think here that are relevant to the court's consideration. Number one, Mr. Ross is not incarcerated. I think if he hadn't been able to post bond and was lodged, there's a much greater urgency and certainly the case with that priority in terms of going to trial. So with Mr. Ross being out on bond, the court finds that adjourning the matter doesn't necessarily result in any prejudice to the defense. The court does know that this matter was set for a trial. The trial dates were set and sent out in December following a November status conference. And based on Mr. Ziegler's representations to the court, which I have no reason to disbelieve, there has been diligent efforts on the part of the prosecution to obtain the testing and evidence that they need to be ready for the trial date on February 18th. So the court doesn't find that there's been any lack of exercise of diligence on the part of the prosecutor's office. Also, the court generally grants adjournments pretty freely to the defense. They're very rarely requested by the prosecution. And this is the first request for an adjournment. Finally, the court would note that, again, the clock really started running on this case in terms of timeliness, in my view, in November when the trial was requested. So we're only a couple months out from that. Mr. Ross was bound over in mid-September. So as these things go, there hasn't been a terrible amount of delay in this case, such that the court finds there would be prejudice to the defense. So for all of those reasons, the court finds there is adequate cause to grant the adjournment. The court will reset the trial as well as another final status conference for a one-day jury trial. The court is unlikely to grant any further adjournments for testing. So Mr. Ziegler, whatever you need to do to spur that on will need to happen for the next trial date, and then we'll go forward at that time. Mr. Ziegler, I would just request that you prepare an order reflecting the motion on the record here today, as well as the court's ruling, and submit that under the 7-day rule or with the stipulation as the form.
Yes, right.
Okay. Mr. Ross, it's important that you continue to stay in touch with your attorney, and will be provided with the notice of the date and time of the next hearing date. Okay. All right. Thank you. That's all.
Then your Honor, Mr. Farmer is also in the courtroom.
People versus Farmer, file number 255130. Mr. Farmer, come up to the podium there, please. The record should reflect Mr. Farmer's present here in the court today. I'd like to have counsel put your appearances on in this file.
Ryan Ziegler again.
Thomas.
I have this set for a plea hearing today. Mr. Seeger, how did you want to proceed in this case?
Sure. At this time, Mr. Farmer has indicated that he wishes to proceed the trial. I would note that he's rejecting the offer where he was offered an opportunity to plead to one count of lewd lascivious, which would have been a 1-year misdemeanor. Most notably, implicit in that is that there's no SORA requirement related to that. But to that end, Your Honor, he wishes to proceed to trial.
Mr. Ziegler, how much time do the people need to be ready for trial in this case?
We could be ready within, or at least 60 days, Your Honor.
Okay, Mr. Seeger?
That's fine. Yeah.
Okay. And Mr. Ziegler, how many days of trial would we need in this case?
Your Honor, even though it's a criminal sexual conduct case, I probably only have 2 or 3 witnesses. I think we could get it done in 1 day.
Mr. Seeger?
I agree. Yeah.
Okay. So we'll set it for a 1-day jury trial. I'm going to put the time frame as 60 to 90 days. The court will set this for a final status conference prior to the trial date. So, Mr. Farmer, there'll be one final hearing here in court before we have your trial. And that hearing date would be the plea cutoff, so that to the extent that you wanted to further consider any plea offers, that would be the last day to enter into any plea agreements, okay?
Okay.
Also, that'll be the motion cutoff, so to the extent that either side has any motions, they need to be filed and set for hearing no later than the date of that final status conference. And Mr. Farmer, you'll be provided notice of the date and time of that hearing as well as your trial date. Between now and then, it's important that you stay in touch with Mr. Seeger so that you're prepared to go forward on both of those days, okay?
Yes, sir.
Do you have any questions at all?
No, sir.
Okay, thank you. That's all for today. Counsel, put your appearances on in this file.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger, appearing with an on behalf of Mr. Bishop.
And Mr. Seeger, how did we want to proceed in this file?
Your Honor, it's my understanding that Mr. Bishke is going to tender a plea to aggravated domestic violence in exchange for this instructing.
Ziegler, is that a correct statement of the plea offer?
It is, Your Honor.
Mr. Bishke, have you had an adequate opportunity to speak with your attorney about this plea agreement?
Yes.
And is that how you wanted to proceed today?
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Mr. Bishke, are you currently on any kind of probation or parole?
No, not yet.
And you understand that the maximum possible penalty you could face for aggravated domestic violence is up to 1 year and or $1,000 fine?
Yeah.
With that maximum possible penalty in mind, what is your plea to that charge today? You have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes.
And you understand that you're going to be giving up and waiving all of those rights by pleading guilty?
Yes.
Did you have any questions about that?
No.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anybody promised you anything other than what we've said here on the record today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty to this crime because you are actually guilty?
Yes.
The information I have indicates that this happened back on November 14th of 2025. Is that the correct date?
Correct.
And on that date, did you have an altercation with an Ashley Martinez?
Correct.
And were you residing in the same household as that individual?
Yes.
Did you have a dating relationship with that individual?
Yes.
And what happened during that incident that would make you guilty of this crime?
We got into an argument and I shoved her and she fell and hit her head. And that was that.
Okay.
And then she left.
All right. And where did that happen at?
In the kitchen. Area.
Okay, of your residence?
Correct.
And is your residence located within Kalkaska County?
Yes.
All right. Mr. Ziegler, are the people satisfied with the factual basis?
Your Honor, there needs to be some testimony as to an aggravated injury requiring medical attention.
Oh. So she hit her head, is that correct?
Correct.
Okay, did she need to get some medical attention for that injury?
Yes.
Did she cut her head or what was the kind of?
She fell back and hit her head on the counter of the sink in the bathroom.
Okay. Did she have to get like stitches or something like that?
4 or 5 staples.
Okay. All right, with that, Mr. Ziegler,
I'm satisfied.
Mr. Seeger.
Yes, sir.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, sir.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sir.
Thank you, sir. The court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date, and time of that hearing. Ms. Wagner, do you want Mr. Bishke to stop by the probation office today?
Yes, please. Thank you.
Okay, so Mr. Bishke, before you leave today, go next door to the probation office and check in with them. And make sure that you stay in touch with Mr. Seeger prior to that sentencing hearing, okay? Did you have any questions at all? Thank you. From Wexford County Jail, if I could have both counsel put your appearances on.
I am Ziegler. I'm here for Your Honor.
Good morning. Thank you, Honor Ravi Gurumurthy. I'm appearing on behalf of Mr. Griffith.
All right, this is set for a final status conference today. We do have trial set to begin in this matter on February 18th. This is also the plea cutoff. So this is the last date to enter into any plea agreement prior to trial. Mr. Mertz, have you been able to discuss that with your client?
I have, Your Honor, and we've had some extensive discussions. I've had some extensive plea negotiations with Mr. Ziegler's office. We've reached a resolution. My understanding is Mr. Griffith would enter a plea of no contest to 6 counts of felonious assault. The remaining 9 counts in the felony information would be dismissed. There is no sentencing agreement, Judge.
Okay, and what would be the reason for the no contest plea?
A potential civil liability, Judge, and Mr. Ziegler and I did previously email Ms. O'Rourke at your office a copy of the transcript of the preliminary exam that establishes factual basis for the no contest plea for those 6 counts of felonious assault.
All right, thank you. Mr. Ziegler, is that a correct statement of the plea offer in this case?
It is, Your Honor.
Okay. Mr. Griffith, were you able to hear all of that?
Yes, Your Honor.
And have you had an adequate opportunity to speak with your attorney about this plea agreement?
I have, Your Honor.
And is that how you wanted to proceed today?
Yes, Your Honor.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Griffith, are you currently on any kind of probation or parole?
No, Your Honor.
All right, and you understand that for each count of felonious assault, that the maximum possible penalty you could face would be up to life. I'm sorry,
4 years and or $2,000, Your Honor, for felonious assault.
4 years. Sorry.
That's correct, Judge. It's 4 years and a $2,000 maximum on the 4-year count.
Okay, so Mr. Griffith, you understand that that is the maximum possible penalty for each of those counts?
Yes, Your Honor.
With that maximum possible, is there any, Mr. Mertz or Mr. Ziegler, are either of you aware of any potential consecutive sentencing sanctions in this case?
I am not, Your Honor.
And neither am I, Judge. There should be no consecutive sanctions in this case.
Okay. So, Mr. Griffith, with that maximum possible penalty in mind as to each of those charges, what is your plea here today?
No contest, Your Honor.
All right. Right now you have certain rights, Mr. Griffith. I'm going to go through those rights with you here on the record. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand that you have all those rights?
I do, Your Honor.
And you understand that you're going to be giving up and waiving all of those rights by pleading no contest, and you won't have those rights anymore, including that right to have a trial.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of that appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead no contest?
No, Your Honor.
Has anyone promised you anything other than what we've said here on the record today?
No, Your Honor.
And is it your own free choice to enter this plea?
Yes, it is.
All right, so based on the stipulation of the parties and the stated reason of the potential civil liability, given the nature of the charges in this case, the court finds that that's an adequate basis to accept a no contest plea. I also did receive, as indicated by Mr. Mertz, the transcript electronically. I had a chance to review that transcript prior to the hearing today. Mr. Ziegler, have you reviewed that transcript?
I have, Your Honor.
Would you agree that the testimony contained within that would establish a factual basis for 6 counts in this case?
I do.
Mr. Gurmurthy, have you done the same?
Yes, sir.
Would you agree as well?
And I would.
All right, Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Gurmurthy, are you?
No.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this no contest plea?
Yes, Your Honor.
Mr. Gurmurthy?
I concur.
Thank you. Mr. Griffith, the court finds that your plea is knowing and voluntary. I'm satisfied based on my review of the transcript as well as the stipulation of the lawyers that there is testimony in that transcript that would establish a factual basis for a finding that you are guilty of 6 counts. The court will accept your no contest plea as to all 6. We will set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, you'll be contacted by the probation department for a pre-sentence investigation. Once they prepare that report, you'll have an opportunity to go through that with your attorney, and then we'll set this for a sentencing hearing. Do you have any questions about how we're going to proceed with your case?
No, Your Honor.
And then finally, the court will adjourn. The trial date's currently set for February 18th through the 20th in light of the plea here today. Mr. Gurmurthy, anything further on your client's behalf?
Two things, Judge. One, I would like to be present at the pre-sentence interview with my client. I know Ms. Wagner and Ms. Welkeron, so I know one of them will reach out to me to schedule that, but I wanted to just inform them that I'd like to be present. Second is, Judge, I'd like to argue bond on behalf of my client. Bond with the original charges, understanding that that's what he was charged with, was set, I believe, at about $8 million. Mr. Griffith has been cooperative. He has accepted a plea to the felonious assault. I would ask that bond be modified accordingly. Mr. Griffith has no prior criminal record. I've been in contact with Mr. Griffith's wife, who lives in Kalkaska County. He has 2 minor children. I think one is 2.5 and one is about 6 months old. Mr. Griffith is not a flight risk. His property is in Kalkaska County. He is a resident of Kalkaska County, has local ties to the community through friends and other individuals through his homestead. Certainly, Mr. Griffith is not opposed to being on any sort of GPS monitoring or tether. He would abide with the no contact orders that the court would impose. There is no concern of drugs or alcohol with Mr. Griffith, but certainly if the court requires Mr. Griffith to comply with any pretrial services, he would do so as well. I would argue that in this matter, that the bond be set at $20,000, 10% to secure Mr. Griffith's appearance at sentencing. And Mr. Griffith is going to appear at sentencing. I have no issues with him being a flight risk, Judge.
Mr. Ziegler?
Your Honor, I think regardless of whether the plea is to the 9 felony counts that were initially charged, or the 6 felony counts that he's pled to, it's clear that this is a serious offense. It's an offense that involves endangerment of the public and of the victims particularly. I do agree that a bond of $8 million cash or surety probably would not have been warranted had we started with just counts of felonious assault, but that's not how this case has developed. I believe, and the guidelines are always subject to the court's approval, but my belief is that the guidelines for the felonious assaults are going to be 5 to 23. It's very likely that Mr. Griffith will still have to do some additional time, depending on what the court sentence is, obviously. And so I don't think that a modification of bond at this time is warranted.
All right, thank you. Mr. Griffith, there's a number of things that the court has to take into consideration when it comes to the amount and conditions of bond. Number one, I think there's been a plea in this case, so we're no longer in a pre-trial type posture here. Mr. Griffith has pled guilty, so it's no longer a question of guilt or innocence in this case. I mean, he's pled no contest, but he's accepting responsibility for these crimes. So I don't find that Mr. Griffith would be entitled to pretrial release at this time, regardless. But the court finds that given the nature of these crimes, which are assaultive, there are numerous offenses here that Mr. Mertz pled no contest to. Regardless of amounts or conditions, the court finds that it would be in the interest of public safety to have bond remain where it is pending a sentencing hearing in this case. The court also agrees with Mr. Ziegler in terms of a potential sentence. If those are the guidelines, it's likely that Mr. Griffiths is going to continue to accrue credit for a sentence that he would ultimately be required to serve. So for all those reasons, the court finds that bond should be, the motion for modification of the bond should be denied. The bond will remain as set. And again, we'll set this matter for a sentencing hearing at the court's next available date. So aside from that, Mr. Gurmurthy, that sentencing hearing will be in person. So I'm going to request Mr. Griffith will obviously be brought here. I'm going to request that you're present here for the sentencing hearing as well, in case he has questions or needs to go through things with you. That'll be easier to do if you're here.
Yes,
In
sir.
light of the original information, Mr. Ziegler, and the plea agreement here, I am going to ask that you prepare an amended information with the new counts added to that, so that just given the nature and the number of charges here, I think it'll be cleaner for the file as opposed to trying to just do that for the record. Can you get that filed with the clerk's office today?
I believe so, Your Honor.
Okay. Mr. Ziegler, anything further from your standpoint?
No, Your Honor.
Mr. Gurmurthy, anything further today?
No, sir. Thank you.
Okay. All right. Thank you. That's all for this hearing today.
Thank you, Judge.
All right. People will call the court will call People versus Lloyd Dennis. This is file number 25-5118. Dennis is present here in the courtroom today. This is the date and time set for sentencing in this matter. If I could have counsel for your appearance.
Thomas Seeger, appearing on behalf of Mr. Dennis.
Dennis, did you have an adequate opportunity to go through the pre-sentence report and talk to Mr. Seeger about that? Okay. Mr. Seeger, are there any additions, deletions, or corrections to that report?
There are not.
Are there any challenges to the scoring?
Not by me here.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for elocution today?
Your Honor, I think the recommendation of the jail sentence in this case is appropriate. Mr. Dennis was on probation at the time of this offense. He relapsed. And he was charged with possessing fentanyl. His track record on supervision is poor. He did not complete residential treatment. He did not comply with probation terms, and he failed to appear as ordered for his PSI interview. A probationary sentence in this case would accomplish very little. As such, his track record warrants a sentence that sends a message to him that his continued controlled substance use and his continued violations of court orders and court supervision will have serious consequences. I would ask the court to impose 6 months in the county jail with credit for 33 days served.
Thank you, Mr. Seeger.
And Your Honor, just on behalf of Mr. Dennis maintains that he did in fact complete treatment. Whether or not he did, I don't have any verification of it, but he is representing that he did. But probably what's more pointedly important is that Mr. Dennis indicates that he understands that he has a substance abuse problem for which he wants to get back into a treatment type setting. Unfortunately for Mr. Dennis, he has other problems because he still has to deal with his Benzie County case, which has a greater penalty. It's difficult in these cases because in most instances, people who have substance abuse problems do have relapses, just like Mr. Ziegler said. This is not a situation wherein Mr. Dennis is alleged to have been selling drugs. He's probably more of a danger to himself than he is to the public. And unfortunately for him, he needs to continue to work on maintaining his sobriety, which I think he's struggled with for a variety of reasons, some personal reasons, a lot of different reasons, but he's trying to stay on the straight and narrow. He recognizes that he has struggled at times. He recognizes that jail may come from this. The recommendation, the guidelines are 0 to 9 months. The recommendation is for a jail sentence. He served 33 days. I would ask the court to consider closing this file without further incarceration, he clearly will have to go back to Benson County and address his underlying probation violation on a much greater charge. This is really a case of probably malum et prohibitum. Unfortunately for him, in Benson County, he's on 7411. I suspect, albeit I don't want to speak for the court over there, that there's probably a good opportunity that he's going to lose his 7411 status for him as the court. And that would probably be the greater punishment. Whatever it is that the court does, he's hopeful that the court will allow him to get into treatment, which he clearly needs, which one way that he'll be able to accomplish that is presumably through a sentence in Benzie County if they afford him that opportunity. But if the court sees fit to allow or to sentence him to some kind of jail time, he would just ask that a condition of the sentence allow for him to get into treatment to the extent that Benzie County allows him to get into treatment. The other problem, Your Honor, would be that I suspect that in Benzie County, he's probably more likely to face a greater amount of jail time than he would be here. If we sentence him, theoretically, we are probably holding him for the benefit of Benzie County. But that doesn't mean that there's not a punishment for his own act. Just as a matter of practice, it seems as though logically that perhaps Benzie County, if there is a punishment, it is resolved through this underlying probation violation, at which point it would be their responsibility to house him. And if he's able to get treatment, which he's indicated he wishes to do, that would be helpful to him and everyone else. So he's just asking for that opportunity.
Thank you. Mr. Dennis, anything you wanted to say today?
No, sir. It's been a long road.
All right. I did read through the report, so I'm familiar with what happened in this particular case, as well as just your general circumstances and your past history and so forth. And so I take all of that into account, along with what the lawyers have had to say here on the record today. It sounds like your probation in Benzie hasn't gone real well. And certainly this is not helping things, this additional charge here. Based on the information contained within the report, I mean, I'm satisfied that you do have a substance abuse issue that you do need to work on. The question is whether we're going to continue to put court resources towards that, or whether that's something that you need to do on your own because you want to stop going to jail and you want to just live a better life for yourself. In this case, I agree with the recommendation that further probation here is not going to be helpful either to you or to the community. I think to the extent that Benzie's willing to continue you on probation, then that's where that should occur, as opposed to here in this case and adding an additional term of probation on. I also think that while it appears you've made some requests to get treatment and have at least attempted treatment in the past, and this report indicates it wasn't successful, I don't have any information one way or the other, but certainly the report documents a lot of failures on bond, a lot of positive drug screens and so forth, or just non-compliance, which indicates to me that even though you're expressing a desire to get treatment, you're not following through with any of those expressions, or not doing anything to get yourself in a position where that can happen, or where the court would be willing to order that or make that part of the sentence. So I think you need that. I think it's something that you're going to need to do on your own, rather than being ordered by the court to do it, because I don't think just the court ordering you to do it is going to make it happen. I think you've got to make that decision inside yourself that that's what you want and take the steps to get better. In this case, I think given your total circumstances, the guidelines are 0 to 9 months. I think a reasonable sentence is 5 months in the middle of that guidelines. I think that accounts for your failures on bond and for your conduct in this case, but also is shorter than the maximum sentence under the guidelines, and will give you an opportunity to seek treatment sooner than you might otherwise be able to. So the court is going to sentence you to 5 months in the Kalkaska County Jail. You do have credit for 33 days served. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of the sentence. We're going to provide you with some papers, Dennis, that explain to you what your appellate rights are, as well as how to request the court appointed attorney.
For the record, we're saying it's for rights.
Or into the custody account at this time.